Yes, ladies and gentlemen of the press, what I said and what my two colleagues have said can be summarized as follows. One, recall that MAZI NNAMDI KANU'S case was commenced almost over 9 years ago when he was first arrested in Lagos. Recall also that he was then charged with offenses relating to his broadcast on Radio Biafra from his location in London. You can imagine what it means for someone to be on an endless trial that never really happens for almost 10 years and being detained without conviction for 18 months, initially from 2015 to 2017, and again for over 3.5 years from 2021 to the present day. This alone is a gross injustice of its unique kind. Two, it's also to be recalled that after MAZI NNAMDI KANU was freed on bail, Nigeria's army levied these lethal attacks against him that drove him into exile, involuntary exile, from which he was also renditioned in 2021. And recall the decision made in 2018 by the African Union that everything that has happened to the IPOB from 2017 to that very date, and of course, much worse happened after. Recall that those things were declared illegal and unlawful, and as having violated the African Charter at a continental scale. Now, also, the same action, in particular, the proscription of IPOB in 2017, provoked or triggered the rush of litigation that eventually culminated in the ruling of the High Court of Enugu State, declaring that such actions by the federal government of Nigeria against MAZI NNAMDI KANU and IPOB are unconstitutional. So the question to ask is this: why is it that the IPOB, being of Igbo stock, it is not us as legal team making allegations? We have rulings of the international community. In the same vein, we have rulings of municipal courts in Nigeria indicating that what is happening to IPOB is nothing more than an ethnic-driven persecution. 3, now having survived the lethal attacks and having survived these many years in enforced exile, and having undergone all these tribulations and travails, and having been renditioned, these actions, this very action of the federal government of renditioning MAZI NNAMDI KANU triggered the international legal order. In July 2022, the United Nations Human Rights Council came down with a gavel that MAZI NNAMDI KANU was extraordinarily renditioned, and that it was a violation of all canons of international law to which Nigeria is subject, and it recommended a generous compensation to be paid to him and cessation of his prosecution. That was ignored by the federal government. 4, it is noteworthy that on 29th June 2021, as indicated before, MAZI NNAMDI KANU was arraigned, well, you can say produced in court, albeit secretly, through the back door, and presented before Honorable Justice Binta Morizala Nyako, who was aware that MAZI NNAMDI KANU had counsel of record. The prosecution was aware MAZI NNAMDI KANU had counsel of record, not us, his former lawyers. And the DSS was aware of the information of his counsel of record. Everything was on file. Yet MAZI NNAMDI KANU, or the court, conducted hearing over the head of MAZI NNAMDI KANU and remanded him to DSS custody without notice to his counsel, not to talk of presence of his counsel. This is a flagrant violation of Section 36 of the Nigerian Constitution. 5, when you fast forward to October 2022, when the Court of Appeal discharged MAZI NNAMDI KANU, there was also a judgment issuing from the Federal High Court sitting in Umuahia, which had declared his rendition from Kenya as unconstitutional. It didn't stop there. It went as far as declaring his continued detention in Abuja as unconstitutional.